Tennessee is in session.
Well, good morning. I'm getting ahead of myself there. Good morning, Council, and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate with us today via Zoom. We believe that's probably the most effective and safest way to conduct oral arguments for this period of time. However, it's my understanding that we're going back to in-person oral arguments next month, so this should be your last oral argument before the Court of Appeals for the month of March anyway, by Zoom, that is. Even though we are conducting this argument via Zoom, the same rules and protocol that would be in effect as if we were all in the courtroom together is in effect, and we appreciate you following those procedures. I also want to advise you that if we experience any technical difficulty, and we certainly don't expect to, then everybody just remain calm. We'll get it fixed, and we'll make sure that it does not prejudice anyone's rights. Before we get started, I want to introduce our panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the case?
No, Your Honor.
All right, you may call the case, please.
Christie Lee Vanwinkle et al. Versus Robert Martin Thompson.
And Mr. Upchurch, it's my understanding you're not reserving any rebuttal time. Is that correct?
That is correct, Your Honor.
All right, you may proceed, sir.
Thank you, Your Honor. May it please the court, I represent the appellants and the original plaintiffs in this action. Christie
we know who you are, but we need you to identify yourself for the record because it's all being recorded.
All right. I am Howard Upchurch, Your Honor. I represent the appellants, Christie Vanwinkle and Scott Vanwinkle.
All right, sir, you may proceed.
Yes, Your Honor. This is a defamation action that was filed in the Circuit Court of Putnam County. This appeal is really a single issue appeal. And the issue is whether or not the false statements that were made by the defendant appellee, Mr. Thompson, in a declaratory judgment complaint accusing the appellants of the commission of the crime of bigamy are protected by the absolute litigation privilege. This defamation action, Your Honor, actually is one of three cases involving the parties or a combination of the parties. It arises out of a divorce action between Ms. Vanwinkle and Mr. Thompson in Putnam County, and that was case number 2015 CB 229. This court, approximately 2 months ago, conducted oral arguments on the issue that remained in that divorce action and issued an opinion. I believe it was February 9 of 2022. Ms. Vanwinkle and Mr.
Is that case
Thompson.
final now?
I'm sorry.
Is that case final and concluded?
The 60-day period for filing the application for permission of appeal, I believe, expires April the 8th.
Okay, so it's, as far as we're concerned, still a live case.
Yes, Your Honor, it is.
All right, thank you.
All right, thank you. Ms. Vanwinkle and Mr. Thompson were divorced by a final decree of divorce in their divorce action that was entered December 22 of 2017. Mr. Thompson was the only party who appeared before the circuit court that day with his attorney, my good friend, Mr. Fincher. The decree was prepared by his attorney, and the decree was actually attached as an exhibit to the defamation complaint I filed. And pertinent to the issue before the court today, the decree reflected in the first paragraph that the divorce would be granted at this time, reserving all other matters, but not limited to property division and alimony. The court then found in the decree that the bonds of matrimony existing between the parties should be dissolved and the parties should be divorced and restored to the rights and privileges of unmarried persons. And then the decree in the order section ordered the parties to the action to be granted an absolute divorce and restored to all rights and privileges of single persons. The language in the decree, Your Honor, as I said, is very important to this defamation action. After the decree, the final decree was entered, and the final decree did not reflect the that there were any other issues to be reserved other than division of property and alimony. After the decree was entered, the parties then appeared before the Putnam County Circuit Court, Judge Hollers, on March 19 of 2018 for the hearing on the division of the property and alimony. The case, we thought, was concluded that day by agreement. The parties then developed a dispute primarily over how my client, who is a principal and a career educator, how her Tennessee Consolidated Retirement System benefits were to be divided. And that was the issue that the court, with all due respect, addressed a couple of months ago. An order was entered in that case after the March 19, 2018 hearing. An order was actually then entered, Your Honor, on October 29 of 2018. 2 days before that order was entered, my clients, the plaintiff's appellants, Mr. Vanwinkle and Miss Vanwinkle, married. On November 21 of 2018, and that was within 30 days of entry of the order dividing the parties' personal properties, my client, Miss Vanwinkle, filed a Rule 59 motion to alter or amend the order dividing the parties' personal property. And that motion did not address the final decree that was entered in December. Mr. Fincher nor his clients filed any motion, never filed any motion that attacked or addressed any provision of the final decree. So the issue in the Rule 59 motion that we filed, again, was the division of the plaintiff appellants, Ms. Christie Vanwinkle's Tennessee Consolidated Retirement System benefits. While this motion was pending and had not been yet argued, Mr. Fincher filed a response on behalf of Mr. Thompson, the defendant appellant. The same day he filed the response, Your Honor, that was on July 19, 2019, he filed in a separate action. It's in case number 2019 CV 156. He filed an action for declaratory judgment and to invalidate a bigamous marriage. That was the style of the complaint that was filed. That complaint was filed by Mr. Thompson. It named as defendants the plaintiff's appellants. That action, Your Honor, was subsequently dismissed by the court upon a Rule 12 motion that we had filed on behalf of the plaintiff's appellants in this case for a number of reasons, including primarily the fact that the parties were in fact divorced in December of 2017 and that the complaint failed to state a cause of action against my clients. Now, on August 5 of 2019, in light of the filing of the complaint accusing my clients of the crime of bigamy and a bigamous marriage, we filed for the plaintiff's appellants this defamatory judgment action. The defamatory judgment action proceeded to a hearing on a motion to dismiss filed by Mr. Fincher on behalf of Mr. Thompson. And that brings us to the issue here today. Mr. Fincher argued that what was set forth in the complaint for declaratory judgment and to declare the marriage bigamous was protected by the absolute litigation privilege. In other words, that even if the remarks of the comments were defamatory comments, they were protected by the absolute litigation privilege. And as Mr. Fincher ably briefed, that is a privilege and a well-respected and well-known theory of law that's been around throughout the jurisprudence of this country. But in any event, for today's purpose, and the issue in this case is whether or not the privilege applies, given the fact that the only issue in the divorce action that was remaining and subject to litigation at that time was the division of the Tennessee Consolidated Retirement System of my client's benefits. Not whether or not the parties were divorced, not whether or not the divorce would be set aside, simply how those retirement benefits should be divided, what the parties' agreement for the division was, and more specifically, how the statutes and the rules applicable to marital property and the division of Tennessee Consolidated Retirement Benefits should be applied.
Let me ask you a question, Mr. Upchurch.
Yes.
On the issue that you're discussing here, I'm looking at the court's order, and in number 4, it says the court finds that the alleged defamatory statements were each pertinent or relevant to the issue involved in said judicial proceeding. A couple of questions. Number 1, I'll let you explain to me what your thoughts are on that court's finding. Is that a finding of fact or a finding of law, and how are we supposed to examine that?
Your Honor, I raised that in my second section of the brief under my 12.02 B6 argument, whether or not the court could decide this without facts. The way that
was there, and we haven't seen the record, so we don't know. Was there a hearing held, or was this simply legal argument?
Legal argument, Your Honor. There were, I think, 3 lawyers at that time that participated in the legal arguments, but it was only legal arguments and an examination of all the various pleadings and documents that had been filed at that point in 3 different files. So,
do we have a transcript of that hearing?
We do. We do.
Okay.
It's been filed, Your Honor.
All right.
I think it can only be a finding of law. I don't think it can be a finding of fact. And I raised that, Your Honor, as an issue because I think, with all due respect to Judge Hollers, who's an excellent jurist, I think she went beyond what she could consider and what she should have considered in the 12.02 motion. But in any event, in my opinion, it is a finding of law. So if the absolute litigation privilege applies, the court has to determine that those defamatory statements had some relationship to that one issue before the court in the divorce case. And our argument, Your Honor, is it absolutely did not. It was not pertinent to it. It was not relevant to it. It added nothing to the issue that was before Judge Hollers in the divorce case at that time. Therefore, Your Honor, the absolute litigation privilege does not protect the pleadings and the allegations that were made by Mr. Fincher and his client in the declaratory judgment action. And because of that,
explain its reasoning any?
I'm sorry?
Other than, did the court explain its reasoning any other than this statement in the order?
The court, and we argued that, Your Honor. We argued this very issue with Judge Hollers. I did. And I'm certainly not trying to say that the judge didn't consider what we're considering here today, but the court, I think, simply decided that these are all a part and parcel of the same case. They're all kind of bundled together. And the judge felt like the absolute litigation privilege then protected those allegations that were made in the complaint. And Mr. Fincher may have another view of that, but I believe that's a fair summary of Judge Hollers' findings in regard to the application of the absolute litigation privilege. That was the third issue she addressed that day, Your Honor. She had addressed the TCRS benefits, that issue. The second thing she addressed was my motion to dismiss Mr. Fincher's complaint for declaratory judgment and bigamous marriage, which should rule favorably for me. The third issue then was Mr. Fincher's motion to dismiss the defamatory judgment action based upon the absolute litigation privilege. So that's where we are. As I said, I think it's a rather simple case. It's simply how the court determines the relationship of the declaratory judgment complaint with the original divorce action, the issue before the court. We say it's not relevant, not pertinent, and therefore the litigation privilege does not apply. The case should be remanded, and we should be able to try our case on our allegations of defamation of character for these plaintiff appellants.
All right, sir. Anything further?
No, Your Honor, that's it. I'll be happy to answer any questions, of course, but I think, as I said, it's a rather simple case. No offense to the court, but it's a single issue case.
We have heard that things were simple before, and sometimes that's true and sometimes not so much. All right, thank you, sir. We'll hear from Mr. Fincher on behalf of the appellate.
Good morning, Your Honors. May it please the court. I'm Hank Fincher, and I represent the appellee, Robert Martin Thompson, in this case. I agree with my friend, Judge Upchurch, that it's a single issue case, but his focus respectfully is on the wrong issue. The findings by the court were based on our pleadings in the declaratory judgment action. The defamation case is based entirely on statements made in those pleadings. That litigation, the bigamy litigation, if you want to call it that, or the declaratory judgment action, was very much alive and at issue at that hearing. My friend just pointed out that Judge Hollers held a hearing on those three different matters, three separate proceedings in one hearing between these two parties. And so she found, I think it's a de novo review, because whether it's an issue of fact or law, it's related to our pleadings. That pleading in the declaratory judgment action was not allowed to be made part of the record. Both Judge Upchurch and I agreed to put it in the record, but I think we didn't get Judge Hollers to sign it in time or something. It's attached to my brief as an appendix, so it's there to be read. So we don't have to remand it or send it back down. You can see it. It's also set forth in the text of my brief on pages, give me a second, pages 2 and 3 of my brief, my statement of facts. It has the operative language. And she sued over that. And that's why the absolute litigation privilege applies. Lawyers are allowed to say things in lawsuits that we might not be able to say out in the street, because courts are a place where we need to have wide open debate. Now, even if, and we contend that it was not only non-defamatory, it was accurate, but that's secondary. The statements were made in the complaint for the declaratory judgment action. And so the judge ruled on that in the same hearing where she dismissed the defamation action. So were they pertinent to that declaratory judgment action? Most definitely. That was the whole issue. Was this a bigamous marriage or not? And
is that the issue, Mr. Fincher, pertinent to the declaratory judgment action or pertinent to the divorce? Is it one or both, or what are we looking at what they're relevant to?
Sure. Well, we had 3 different lawsuits pending when she held her hearing that we're here on. And as noted by my friend, we had 3 different lawsuits. We had a divorce issue where it was still open. It was still live. It had not been final. And as this court knows well, if it's not final, it's not final. It has to be final in all, or it's not final in any, unless it has the Rule 5402 language. And the 2017 divorce order did not. With hindsight, I think Judge Upchurch and I wish that we had included it, but we didn't. And as a technical matter, no matter what we wanted or intended, that left that one open. So we had that pension issue that Judge Clement just ruled on a couple months ago in the divorce. We had the bigamy suit, the declaratory judgment action, where my client sees his ex-wife remarry before the divorce is even got its first final decree, that she then files a Rule 5904 motion, preventing it from becoming final. And he's like, what has happened? What is this? And I look at it and I'm like, it doesn't look final to me under the rules. And so we do what we're supposed to do. We go to court, we file a declaratory judgment action, we lay out the facts, and we say, if she's married another man before her divorce is final, then that's bigamy. That's what we said. I don't think that's defamatory. Whether it's accurate or not, the court held a hearing on it. Now, respectfully to our friend Judge Hollers, I think she made a practical ruling. She dismissed the declaratory judgment action, declared the marriage had been divorced and her new marriage was valid. And that was fine with my client. He didn't want to be in this mess, but we had to file a declaratory judgment action to find out. And we did. And so that was pending. And then Ms. Thompson files this third lawsuit for defamation against my client for statements made in a pleading. And you can't do that. You can't, it's Hornbook law, it's black letter, it's been the law for 400 years. And we wrote them a letter, I cited the law, we said, hey, you know, this you can't do this, please withdraw it. They didn't. We filed a motion to dismiss, it was granted. And Judge Hollers made findings based on the pleadings. Now, it's a fact that Ms. Thompson's defamation pleading only references statements made in our complaint. So that's a finding of fact based on the complaint. But it's the conclusion of law is that those statements were pertaining to the litigation. And they were all about what I just went through, the timeline and the impact of not having the Rule 5402 language on finality. And so now no one has appealed her ruling in the declaratory judgment action. Everybody was happy with that ruling, regardless of the technical conclusion. The result was very acceptable to both Mr. Thompson and Ms. Vanwinkle. So we get down to really the essence of this. Ms. Thompson wants to overturn the absolute litigation privilege. This issue about the divorce is a separate issue. It was resolved on a separate appeal. The statements in her complaint referenced entirely, solely, statements made in our declaratory judgment action. Oh, my client's declaratory judgment action that I drafted. They weren't defamatory, number one. They were arguing a point of law that I think is valid, although we're happy with the result dismissing the declaratory judgment action.
Is that order dismissing the declaratory judgment a part of our record, Mr. Fincher?
The order dismissing the declaratory judgment action, I know I don't know, because Judge Upchurch and I wanted it to be, and there was an order denying the addition of that. We can certainly supplement the record if Your Honor would like to see it, and we may have put it in through an appendix. I know the order dismissing the defamation action is in this record because that's part of this case as it went up on appeal.
It is in the record. If I may interject, it's attached to the motion to supplement the technical record that I filed, Mr. Fincher and Your Honor.
Okay. The motion was denied. Anyway, it's in there. So good. I defer to my friend. We both wanted it in there. We knew y'all would need it to make sense of this, because it's a simple, narrow issue with a whole lot of history of this case and what's going on. And that is distractive to what's going on here. She wants to sue my client for defamation for statements made in a litigation pleading that was still pending and was dismissed at this same hearing where everything else was resolved. And you can't do that in Tennessee. That's the absolute litigation privilege. We couldn't do that when we became a state in 1796. And it's for good reason. Now, we have a backup argument. We feel like the statement was not defamatory, didn't hold her up to ridicule. It just stated facts and drew conclusions. And the facts are very, very clear from what's been filed. The facts really there's no disputed facts here. And the judge didn't go outside the record that was before her, because she had all three cases sitting there when she made this ruling. They had different case numbers though, which I think is maybe where it got derailed on getting it into this particular file folder. But the judge rightly ruled that she can't sue for defamation for statements made in a pleading. That's the law. And And so she hasn't made an argument respectfully to my friend that would justify that, saying, oh, well, we had this other issue that was resolved at the same time. And that's what we believe. And that's all that we wanted to discuss. Doesn't change the fact that the 2017 divorce order didn't have the Rule 5402 language. And that divorce order is quoted in my brief on page 8. So you can see the text of it there. And so it wasn't there. And so it wasn't final. Now, should we have included that language? Do I now include it anytime that I get somebody divorced and we have other issues pending? I sure do. I've never encountered a situation like this before where somebody like Ms. Thompson, in my opinion, made a deal, then changed her mind. The Judge Hollers found that she had changed her mind, upheld us. The Court of Appeal has now upheld us, saying that she changed her mind. And part of that agreement, this is in Court of Appeal's opinion, part of that agreement was that Judge Hollers would resolve it, and that would be it. It wasn't. She kept on going. She filed a Rule 59 motion in that case, on that issue. But in this case, on this issue, she's wanting to sue for defamation for statements made in a pleading. And there's no exception. There's no outlier. There's nothing other than if the statements didn't pertain to the litigation. And Your Honor, every statement in our declaratory judgment pertained to the party's situation. I mean, the fact is, she married Mr. Vanwinkle on October 27th of 2019. The final order by the judge didn't even get entered until the 29th of October. And then she filed a Rule 5904 motion that prevented that order from becoming final. So the real issue, I guess, as to the truth of the matter, again, that's a secondary defense, right? I mean, even if we'd said ridiculously horrible, offensive, obnoxious things about her, we didn't. But even if we had, they would be protected by the absolute litigation privilege. Even if we'd made defamatory statements about her, called her vile names, then it would be protected, again, as long as it didn't violate Rule 11, the BPR. And that's what the Supreme Court pointed out in the Simpson case, the 2007 case. It's cited in my brief. There are other ways to deal with an attorney who goes rogue and makes awful statements, unprofessional statements about a party. Now, we didn't do that. My friend hasn't accused me of that. I'm sure she was offended by the conclusion reached on these facts, but that's not enough to make it defamatory. So we have somebody that's suing over a pleading for defamation. You're not allowed to do that in Tennessee. You have a pleading that clearly laid out the facts and stated a conclusion, because if you marry someone while you're still married, tell me another word to use other than bigamy. I haven't come across a PC term for that. I guess polygamy maybe, but that, the fact is we called it what it is and used the legal term for it. The case before you is really simple. She shouldn't have filed this lawsuit. She should have withdrawn it when she was advised of the absolute litigation privilege, and she shouldn't have appealed it when one judge told her she was wrong. But here she is, wasting this panel's time trying to overturn a 400-year-old legal precedent without an argument to do so. With respect to my friend who's representing his client and doing the best job that he can, and is bringing all his massive legal talents to bear here, they still haven't come up with an exception that applies to her lawsuit. She wants to sue my client because she's mad at him for saying this, but she's the one that married somebody else before her order was final. So I respectfully submit to Your Honor that the appeal should be denied, that the judgment should be affirmed, and that you should assess frivolous appeal damages in this case. My client should not have had to pay for this. This case is crystal clear on the law and the facts. It's simple. And here we are 2 years later, two and a half years later, still arguing over this. And you shouldn't have had to spend your time on it, and neither should my client. And I'd ask that you assess the damages. If you have any questions, I'll be happy to try to answer.
See none. Thank you. Thank you for your
Mr.
argument.
Fincher,
Oh, I'm
one
sorry.
question. What did you hope to accomplish by filing the declaratory judgment action?
To find out whether my client was stuck in a bigamous marriage or not. I mean, we were looking at all the case, we were looking at everything, and he's like, yeah, she got remarried and she's living the high life. And I'm like, wait a minute, what? And he says, she got remarried. And I'm like, she can't do that, or she's not supposed to do that. And we looked, and he said, am I in a bigamous marriage? Or I don't know if that's his words, but that was, I think they were a little more Saxon than that, but it was basically, what kind of mess do I have here, Hank? I grew up with him. And I said, I don't know. And he says, well, how do we figure this out? And the two choices were just whistle past the graveyard or file a declaratory judgment action. So we filed a declaratory judgment action.
So, and following up on Judge Armstrong's question.
Yeah.
What was there something specific that you were looking for by filing the deck action?
Okay, so we had the whole case going on, right? We have the divorce action going on. We have her appealing everything. We were looking for closure. And as part of that closure, we filed the deck action. We can get closure to that. We could have done it, I think, through an agreed order if we could have agreed on everything. But as it was, we couldn't agree on all the different moving parts. And so we ended up having a court hearing, and two of those rulings out of the three were appealed. So yeah, it would have been great if we could have got it all resolved. But that question, I mean, how we either ignore it and it's still there, maybe 30 years down the line with these people, if they live, I mean, these are relatively young people. They were in their 40s when this case began. I mean, if they live another 20, 30 years, you know, what do you got? So we've got an answer to that question. Judge Holler said denied or dismissed, which was fine. We got an answer. And that was the answer my client wanted. But it wasn't what the orders said under this court's ample jurisprudence on what's final and what's not. And it's a question that I've seen other people whistle past in cases. I mean, you get divorced and you appeal. Sometimes they're certainly dating, you know, what is that allowed or not? And I mean, Judge Upchurch and I had cases where this is going on and it didn't matter. But here there wasn't any way around it other than to take these actions.
Okay. Any other questions? All right. Thank you, gentlemen. We appreciate your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible date. We again appreciate you participating via Zoom. Ms. Angie,
so
anything
much.
we need to take up before we recess to the call to the next case?
No, Your Honor.
May recess court.